Okay, this is Julio Zamora making a statement for workman's comp in Stockton, California, settlement hearing in Judge Grill's court or hearing room. The fact that I received the wrong diagnosis on 3/21/2009. On 4/17, they made a PR2 report 2009 and left out the fact that I ended up in the hospital. I went in there with left leg pain and came out with low back, which is backed up by an MRI, which I gave to Dr. Hubby and was sent to Safeway, and they referred me to Dr. Baby to get the pinched nerve fixed and was denied. I should also note that the PR2 report wasn't signed by the doctor first and last name, and I didn't sign it first and last name, and it's required. So I'm asking Judge Gill if he can consider making it invalid because of the fact that he didn't sign it. And it was incomplete for the fact that the PR2 report left out the MRI report from the Los Banos Memorial Hospital, who made out an occupational report. So I'm saying that on 3/21/2009 they gave me the wrong diagnosis because of the fact that they didn't take an MRI, the company doctor or Nancy Perdillo or the hospital, whatever. I don't remember everything. Okay, so that was on 4/17. I've been denied benefits. First, I didn't get paid every week or every 2 weeks. On 4/17/2009, I hired an attorney, and I also filed for unemployment, who sent me a document stating that they were in conflict of liability. Conflict of liability. They don't have the right to decide anything. Okay, that was in 4/17/2009. I hired an attorney. The PR2 report wasn't signed, and they didn't have all the information attached to it. The fact that I ended up in the hospital, and that I was suggested to go to Dr. Baby, and it was denied. And I don't know if that has to be on the report or not. But the fact is, he left out information that I think would be important regarding the sprain that they gave me the wrong diagnosis. It was a low back, and they didn't take an MRI. So that happened on 4/17. Okay, on December 1st, I received a notice of offer of work. On December 3rd, I went to work. December 7th, 2010, I was flat out sent home. They then honored a notice of offer of work 3 or 4 times. At least 3 or 4 times. The last time, the attorney sent me a letter in 2013 or 2012 to report to Safeway Tracy and Distribution Center in Tracy, California, to report to work immediately. I did so, and I was denied by them and the union. I should also note that on December 6, 2010, or December 7, 2010, the dispatcher made a statement, and a written statement or a typed statement stating the fact that because I punched in late on the time clock in the driver's room, that I intended to falsify documents behind a letter that was posted on the wall. I should note that the dispatcher took the time from the driver's room and changed my time on my logs. I was hired in 2002 as a Class A driver. I'm an over-the-road driver, and we get paid by logs. And we're instructed to follow the DOT regulation, which is company policy, and union contract. It's a union shop. I should note the fact that the dispatcher took the time from the time clock in the driver's room and changed the time on my logs, which he altered and falsified my logs by taking 20 minutes, changing the time from 10:30 to 11:15, according to his statement. In his statement, he admits he falsified my logs, or he has the authority to falsify logs. Okay, I don't know which one it is, but he changed the time on my logs, which put me in violation of Department of Transportation. And I should go into it a little bit further for the fact that remember that he changed my time to 11:15 in the morning. So if I get stopped on December 7, 2010, and I was stopped by the Department of Transportation, I had to stop at the scales, and they looked at them logs, they would ask the question, how did you go from point A to point B in that short amount of time? I would be in violation and I would be wrote up. So so the dispatcher, he altered or falsified my logs. In 2011, I went to the Highway Patrol Office, Department of Transportation, and I took my logs and stuff that I received in 2011, January 10, 2011, from Mr. Niswonger, or he mailed them to me, one or the other. I don't recall exactly, but the fact is I went to see the Department of Transportation, Highway Patrol Office. And they stated in front of a witness that my logs appeared to be falsified, altered, and which the dispatcher admits that he altered and falsified my logs by changing the time from 10:30 to 11:15 in the morning, and that's his statement that he made out on December 7, 2010. So he falsified my logs and put me in violation. Okay, and then he accused me of falsifying documents on December 7, 2010. And it's like I said, he took the time from the time clock in the driver's room, and that clock in the driver's room pertains to company policy, and I don't know how they figure that, and there's also a separate policy for truck drivers, OTR drivers, in the company handbook. So in any event, I didn't falsify anything. They just flat out sent me home and made false accusations. And the dispatcher admits that he falsified them documents, according to the posting that Mike Sadler posted. That if you punch in late, you intend to falsify documents, which is impossible because it's tamper-proof. And the clock in that driver's room has nothing to do with the logs in the tractor, which the computer in the tractor reports to the mainframe computer. Those logs are not to be altered or touched, and if he does anything to it, it's to make the driver aware of the fact that he altered or tampered with them logs. And he didn't do so, not for me or 400 other truck drivers that I'm aware of. Okay, so we know they have two policies, and we know that he took the time from the time clock and altered my logs. And I have a witness that the Department of Transportation states that somebody altered my logs. Okay, so we know that I'm innocent. And we know that I received a notice of offer of work on December 1st. December 3rd, I went to work. On December 7, 2010, they just flat out sent me home because I received a notice of offer of work on December 1st, 2010. And whether I had 30 days to decide or 20 days to decide whether I want to accept the offer or not. And according to the document or notice of offer of work, it was deemed accepted whether I turned the notice of offer of work in or not. And I should note that they refused to put me to work at least 3 to 4 times. The last time was in 2013. And I should also note that I sent, they changed my insurance supervisor or claim adjuster. They switched it from Esperanza to Miss or Mrs. Morles. And she sent me a notice of offer of work to please sign it and send it in and the shift that I wanted, which would be the same thing that I wanted on December 7, 2010. And that was at 10 o'clock a.m. Eureka run, 14 hours a day overnighter. Okay, and then I was hired in 2002, and I have at least 200 employees underneath me. And according to the contract, they're to pay me for every day that somebody works before me in seniority. And it's a 24-hour operation, 7 days a week. So I should get paid every day at 14 hours a day from December 7, 2010, due to the fact that I was unable to obtain employment because of the dispatcher's actions, falsifying or altering my logs, which prevented me from obtaining employment. So the bottom line is I need to be returned to work so that I don't lose my lifetime medical that I bought in 2002 or 3, and I've been paying for it all this time. Lifetime medical insurance, RSVP. It needs to be replaced, and my benefits and everything need to be made whole. So I'm asking Judge Gill to consider to retire me on my birthday in 2013, and all back pay and benefits, and my RSVP and everything to be made whole on the day I return back to work, and all back pay and benefits at 14 hours a day, 7 days a week. For the fact of what the actions of the dispatcher, I was unable to obtain employment there was no way I'm going to obtain employment with a false accusation of falsification of documents. And this, like I said, I hate to keep repeating myself, but I'm deaf. And I'm getting, Judge Grill ordered a legal document, the attorney to send me a legal document, which I did, and I signed it. Permanent disability, I'm deaf. And the doctor's going to make it out and send it to the legal clinic in Modesto, California, and they're going to send me a copy of that document. Okay, that's about it. The dispatcher altered my logs, and he made a statement stating that that's what he did. And the union has a copy of that, Mr. Neiswanger, and he's aware of that. And that I was flat out sent home, and I wasn't fired on December 7, 2010. And if there's any questions about the fact that the statement that I wasn't fired on December 7, 2010, you need to be informed that the fact that I wasn't discharged on December 17, 2010, that there was a letter sent by the union attorney, local 439 in Stockton, California, that I was discharged on December 16, 2010, which was denied on December 17, 2010. And they gave them 10 or 20 days, whatever it is, to establish the fact that I'm guilty by December 25th, 2010, and to set a date and time for a panel hearing, which was set for January 11, 2011. And I should note that's more than 30 days, and that they didn't respond in 10, 20, or 30 days with registered mail or anything else. And they didn't produce one document showing my error, if there was one. And if you don't respond within 10 or 20 days, you're supposed to be returned to work like 1,500 other Teamsters at Tracy Distribution Center in Stockton, California. They didn't put me back to work. And I should note that they didn't finish the panel hearing. It was put in abyss because I had a severe profound hearing impairment, and it wasn't accepted by Mr. Neiswanger, but he did say he was going to look into it and discuss it with the company. In other words, they would pursue it. There was 2 shop stewards present at the time of the statement, and I also asked the shop stewards, are you an authority on severe profound hearing impairment? Okay, and I was sent home, just flat out sent home, and the panel hearing wasn't finished. I should also note that I asked for arbitration, requested arbitration from the union, and they denied it. And they said that they weren't taking it arbitration because they couldn't win this case, and the fact that they were aware that I had disability issues, and the fact that I could pursue it under workers' comp if I wish to do so, or I wish to do so. So, and that's a statement regarding the union, so it's okay to take it to workers' comp and have to resolve these issues. And so I'm asking for a court order to be returned to work with all back pay and benefits and everything to made whole, with automatic retirement on September 7th, 2013. Automatic retirement, and that personnel to be informed of the court order that I be automatically retired whether I like it or not, and that I do receive the back pay and benefits and all my benefits RSVP to be made whole, and that I receive a letter from the personnel department that I retired from Safeway with a permanent disability. And I have a witness, which I probably don't need one because the dispatcher made a statement on December 7, 2010, and submission of guilt that he altered them documents and accused me of falsification of documents. And he sent me home because of the posting of Mr. Mike Sadler, that if you punch in late, that you intent to falsify logs, when the logs in the tractor, the computer in the tractor is tamper-proof. It's not possible. But anyway, he posted it, and I wasn't late. I got an automatic start every day on this bid at 10:30. At 10:30 start automatic. My computer in the truck has me on duty at 10:30 every day. I don't need to punch in to be on duty. I'm already on duty. But the dispatcher made a suggestion to the fact that I punched in late, and when I was not. So, that needs to be considered to Judge Bill that I wasn't fired and that the dispatcher falsified the documents, according to his own statement that he made on December 7, 2010. And they flat out sent me home, so I'm asking for a court order. And so, I, Julio Zamora, invoke double standards. Life is not fair. A double standard is an application of different sets of principles for similar situations or to different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are not considered unacceptable, taboo when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of bias, morality unfair suspension towards a certain group of the principle that all are equal in their freedom. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence, that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standards should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase, life is not fair, may be invoked in order to mollify concerns over double standards. I should also note that when I was heard on 3/21/2009, I saw Nancy Perdillo, and she commented that it was a sprain. She's a drug and alcohol technician who takes tests when someone is hurt on the job. And I didn't see a doctor. I saw her first, and she stated that it was a sprain. And somebody was on the phone who I don't know, but there was no doctor present. And I didn't see her herself make out an occupational report on 3/21/2009. And I should also note one thing, that that the dispatcher, who changed the time from 10:30 to 11:15, and by doing so he put me in violation of the Department of Transportation. He falsified my logs when he did that. And then he turned around on December 7, 2010, accused me, and then sent me home. So I should like to Judge Grill to consider the fact that the dispatcher is the one that falsified the logs, and he made a statement on December 7, 2010. And the union knows this, Mr. Niswonger, they have the statement, because I saw it. And Safeway has the statement on file, and they're relying on that statement for the fact that that's why they sent me home. They're relying on that statement, a dispatcher statement, which I don't think they realize that he's admitting guilt. It's like a person who robs a store and drops his wallet. Okay? This guy made a statement, and he just made a mistake, and he's guilty. Okay? I'm not guilty. Okay? So that's all I'm going to say about that, and that this is Julio Zamora, and I'm hoping that Judge Will considers my statement. And also, I invoke double standards. Life is not fair, and I hope Judge Gill considers this. And that's about it. Let's see. I got to end it here. Okay.
That's it.